66/2025.
My lords, we represent Ghaziabad Development Authority.
They are here.
I respondent 4 and respondent 3. The matter is coming out on 23rd of February.
Responder 4 only or responder?
4 in 9, we are 4, and in 9.1, we are 3 respondent.
Accept notice on behalf of the so-and-so respondent. Counter affidavit can be filed before 23rd February 26.
Please,
That they will decide all.
please,
Oblige.
oblige.
Then, there is a letter. Item 10, there is a letter circulating.
Please. Madam, this is the third time, my lord, the petitioner has been deboarded forcibly and illegally by the MP police and the RPF with the RPF police. This is the third time this incident happened, my lord. He was not permitted to travel beyond his origination.
So what can we do?
My lord, this is a
How
clear
do
violation of.
how do we examine these facts that you were dropped on the way?
My lord, I have filed the documents, my lord, that police himself given that letter saying that we are deboarding you due to prevailing.
You don't have a place of protest in your state.
My lord, this is the case, my lord, where the.
No, you have a right.
Assured, my lord.
You see, we are not curtailing your right. You have a right to protest.
Yes, ma'am.
Peaceful protest.
My venue is not MP. It is the venue of Delhi.
Yes.
My venue is not MP.
Oh.
In the midway, we were.
Mr. Consul, have you applied to Delhi government authorities?
Yes, my lord, that letter I have annexed. There's
Yes.
no reply. Kindly see the letter which I annexed. 4th of October, I applied for letter. I gave a letter.
Letter
The
you gave, have you
number-
obtained permission?
Madam, permission. No reply has come.
If no reply have come, that does not mean the permission has been granted.
Well, even I presume that even though no reply has come after the representation is given, that means there are no grievance for conducting dharna at Delhi.
If you are ready to listen to us, then you please appreciate.
Yes, ma'am.
There is an earmarked dedicated place for conducting peaceful protests.
Yes, ma'am.
There you can have a political rally, you can have a non-political rally, you can have the farmers as whom you are saying that you represent. The farmers can come there.
No need for poems or bouquets, 'cause my feelings shine in golden rays. A glance, a smile, a pause, a sigh. This is the moment when our hearts align. You don't need roses, words are such. When a golden touch can say so much.
Crispy, creamy, crunchy.
Before the competent authority, I gave a letter.
Yeah.
Even if the letter has to be given in person, I have to come to Delhi at least.
Yes.
But even half of the way, I was deboarded.
How have you, has he engaged you?
Pardon, my lord?
How has he engaged you?
My lord, he is from same place.
So for the purpose of Wakaltanama, for
No, my
purpose
lord,
of,
this is not the way, my lord. Kindly see this. There is a violation, a gross violation of 19(1)D and 19(1)A.
like to answer any question which we are asking you.
My lord, I'm saying, my lord,
How did he come to sign your Wakaltanama and papers?
my lord, as a council, I have to sign it, my lord, that I file a writ petition on his behalf.
You are filing without any Wakaltanama.
No, Vakalatnama I filed, my
Is
lord.
there?
Yes, my lord.
So he came to sign your Wakaltanama?
No, he sent it by post, my lord.
Oh, like, he sent it from there. Now he has authorized you. Why can't you apply?
My lord, it is duly notarized by the local notary public.
Very good. So he has sent it. Now you are his authorized representative. Not
I send it, then there is no reply. That's why my submission.
Go and apply, please. Ask your clerk, you can apply online nowadays. You don't know to, even you are not required to go.
My lord, I'm not saying, my lord, because the question is that the representation has been given, no reply has come.
Well, thank you. very much.
Thereafter-
Thank
Huh?
you. No case to interfere with you.
My lord, at least, my lord, kindly see, my lord, the last writ
No
petition.
case to entertain this writ petition is made. So ये लिखो, the writ petition is completely vague, evasive, and full of misdirected governments. The same cannot be entertained, dismissed. ये रोज फाइल writ petition are dismissed.
Earlier, my lord, I was given permission to go to the High Court, my lord. I applied for the High Court, I filed a writ petition. There also they said we have no jurisdiction to entertain because you were deboarded MP.
No, but your standard does not permit to go to High Court. You are not, your standard is not less than Supreme Court, so you are rightly come
I
to
went to High Court. High Court order also I annexed, my lord. After that,
Very good.
after dismissal of the writ petition, I went to the High Court.
All right,
I
thank you.
pleaded before the High Court.
Thank
High
you
Court
very
said,
much.
"You have
Thank you.
jurisdiction to stop anybody from MP, other than beyond jurisdiction of Madras." That
Thank
is the
you.
reason I have come before Lord.
All right, thank you very much. Next. Item 12.
Lordship, I apologize in this matter. I'm sorry I couldn't circulate letter on time. Mr. Sibbal, who's leading me, he's unwell. So he asked me to make a request. I got information very late. I tried to circulate, but I had surpassed the time. So I'm just requesting 1 week adjournment, Lordship. He's not well. I spoke to him. So,
Your
Next.
monopoly right is expiring when?
sorry, my lord.
May 2026.
Lordship, the patent will expire in May 2026. But there was an injunction till the time the division bench passed the order. So I'm just requesting for a week adjournment. There was an injunction throughout.
Next week.
Much obliged.
But if your lordship, so far as the SecPers lady is concerned, there is no allegation whatsoever. But please come to P4 at 61. That's the FIR. And if your lordships are kind enough just to see para 7 at page number 67. Apart from the invocation of 420, 406, etc. together, Lord, just come to para 7. Complainant, may I place it? May I place it?
Para 17 of?
Para 7 of the FIR, Lord, it said FIR will begin at page number 61. I would like your lordship to see para 7.
Yes.
The complainant ultimately advanced large sums totaling multiple millions of dollars, but as market conditions surged, accused persons began dealing, eventually ceasing delivery. So the whole issue is not, it's really a commercial transaction that we could not deliver because of change of market conditions. Others are surplusage and nothing against the lady, Lord. Nothing whatsoever against the second respondent in the entire FIR. Nothing incriminating. She's just been roped in because of relationship, Lord.
What is the stage of the investigation?
Lord, I must tell your lordship,
Yes,
I
yes.
stated, Lord, charge sheet has been filed.
Let it be investigated.
No, Lord, may I just say this? My Lord, charge sheet has been filed in the interim while the matter was pending in the High Court. Charge sheet has been filed, but I have not been served a copy of it, Lord. Charge sheet has been filed. It really makes out a civil transaction. I have not been served a copy yet because right now summons have not, process has not been issued. It's a case of not give or take of. Charge sheet was filed, Lord, but we don't have a copy. I can place that on record if your lordship permits.
Appear before the. Charge sheet has been filed, then go and,
I'm sorry, Lord?
if charge sheet has been filed, then go and seek your discharge as per law.
Lord, I leave it to your lordship, but not purely a commercial matter where they say it's only a question of delay.
Commercial law depends upon that initially what were intention. If your intentions were right from the very beginning to dupe the investors, then you can't claim it a pure commercial transaction.
Lord, there was an MOU, and I must say this, for the second petitioner, there is, not this lady, there is nothing. May I just have a look at that for a moment?
Not a case that we can question.
Lord, may I just make a request, Lord? May I make a request then? Lord, the concern, I leave your lordship with one more concern. Lord, I was protected till a certain point of time. Kindly just see.
We know that is
Page
only
20.
prayer.
That will be lengthier. You will be released on bail.
Get full. And we'll take our remedies, Lord.
Absolutely.
Yeah.
The petitioners are aggrieved by the judgment dated 22nd December 2025, passed by the High Court at Calcutta in bracket Port Blair bench, whereby their revision petition seeking question of FIR number 34/2025, dated 13 July 2025, registered at Cyber Crime Police Station, South Andaman, has been dismissed. We have heard Sri Siddharth Luthra and our senior counsel representing the petitioner and record and preview the report. It is fairly admitted that after investigation, charge sheet has been filed. That means so, we are not inclined to entertain this petition. The petitioners, if so advised, may move an application for the discharge. Such an application shall be considered by the trial magistrate in accordance with the law. Next paragraph. With a view to enable the petitioners to join the court proceedings, it is directed that the arrest of the petitioner shall remain stayed. Petition number 2. First petitioner, company. It is directed that the arrest of petitioner's number. Petitioner is a company, Mr.
Sorry, not,
Petitioner is a company.
not number two. Second
Number
petition number.
Two.
Number two,
Number
Latifa Banu.
Petitioners number 2, sir.
And there are second, three matters, not the other individual petitioners. In matter two
Petitioners in
and matter three.
SLP criminal number 1790 of 2026 and SLP criminal number 12.
We'll give the name.
825 2026 also shall remain stay subject to their surrendering before the trial court within 1 week and furnishing adequate bail bond to the satisfaction of the trial court. Also, the learned magistrate shall be at liberty to impose such other conditions as may be deemed appropriate, as may be deemed appropriate.
But my lord, we make it 2 weeks is all I'm requesting instead of 1 week, because one of them is based here. Flights are sometimes a little problematic. 2
Right, 2 weeks.
weeks. And one request for discharge will not be influenced by the observations, because there are certain observations on merits.
Nothing, Mr.
My lord. There are some observations on
Thank
merit,
you.
men's etc.
Thank you very much. Thank you.
Grateful.
Please, ma'am. My lord,
Suspension of sentence.
Yes, Mr.
please. My lord, the first round, my lord, the constables came and the ground was that they were simply following the directions of their superiors. Now, my lord, here, they are the advocates and the advocate was throughout present during the commission of the offense. The High Court records that CCTV is not clear and therefore his presence is disputed, whereas, my lord, there was a test identification parade in presence of an executive magistrate and thereafter followed by, my lord, his identification in the court. And, my lord, two, my lord, the High Court records the phone which was found and which was used by this person, my lord. That phone was lost by somebody 6 months back. That's also wrong because it is recovered from him at the time of arrest. Please have a look, my lord, at page. And please see, my lord, he was described as an unidentified person and it was told in the first complaint that once I see him, I can identify. Therefore, a test identification parade was conducted, my lord. Now, please have a look at para 14, my lord. Page 15.
Test identification parade, because the FIR was delayed, was after 4 months of the incident.
My lord, there was an inquiry prior to that. There was an inquiry, my lord. And please see, my lord.
Lawyer's presence was not spelled out in the FIR.
No, my lord, please see. I'll just.
When he goes to the Home Minister and then the FIR gets registered in April.
It
with
was.
regard, we understand that.
Please,
there
please.
are some influence, etc. But still then the fact of delay.
Please.
We have to examine the identification in light of the fact of delay between the parties. And admittedly, this person was advising some of your partner.
No, my lord, he was never, my lord. The High Court records that his father was once upon a time an
Your
advocate.
father was the lawyer of your partner who is the co-accused.
But my lord, he never appeared for me. Please see, therefore I'm pointing out, please see para page 15, my lord.
Yes.
Para 14, my lords, may have a look.
Let's just say the point is that in a case where the.
My lord, in
High
the
Court has
first round, my
granted
lord,
liberty,
when I pointed out that this may not be treated as a precedent, my lords have clarified in the order that
Yes.
in the peculiar facts and circumstances of the case where there were constables simply, following the directions of their superiors, Here, please see the police officers are, IPS officers, The police officers are, a former MLA is before my lords,
Question is, it's a pendency of appeal. But the appeal will be heard, all these.
4 months, 364A, life imprisonment, the evidence is on record, the
High Court has
findings are
made-
flawed.
High Court has made a fine distinction between the conspirators.
Therefore,
The superintendent of police has not been granted suspension.
Milord,
Your partner has not been granted suspension. It's the lawyer, the constable, and the former MLA who have been granted suspension.
but there should
So
be, the
there's a
findings
clarity in
can't be,
the
contrary
degree
while
of
granting
culpability.
suspension, with all due respect. The findings can't be contrary to the record, Please see, therefore I am pointing out, kindly have 2 pages, Para 14 at page, 15. Kindly have a look,
Yes.
It says, the applicant was throughout remained present when the act of ransom and kidnapping being made by the police officials. Hence facts remains that the CCTV footage relied upon the prosecution seems to be not as much as clear. I was there, I identified. And 2, now please see the second finding.
Mr. can clarify that this observation has nothing, will have no bearing on merits. But the point is that once bail has been granted, why?
Milord, yes, I can understand, but this is an offense, Milord. Please appreciate a police officer is posted, Milord, 400 kilometers away. He comes to Gandhinagar from Amreli, and then he abducts. Then there is a transfer of Bitcoin where this MLA is involved. The advocate is present throughout the incident, Milord. Even prior to that, in the conspiracy, Milord. In the conspiracy, right from 7th of February till 11th of February, they were in constant touch. The person who was released, that is Kirit Paladia, and this MLA and these lawyers were in constant touch, on phone. Those are CDRs on record. There were meetings in the circuit house, the government circuit house, That is all, that register is on record.
Question of connecting this entire evidence to establish that there was a meeting of mind or that there was
But,
a
there is no.
preconceived conspiracy, all these are matter of trial. Because it's
Therefore,
not a
there
case of
was a.
substantial evidence.
But, if the findings, are prima facie in contradiction to the evidence on record, just kindly have a look, what the learned judge records, Only one thing. Here, the High Court records that, kindly see page 16, what the High Court has recorded. That the mobile number 816, the last digit, claimed to have lost 6 months back. And then please see page 443, it says, there is a finding that further the mobile number so-and-so recovered from the accused Ketan as per the deposition of so-and-so. So there was a recovery, the High Court records, that it got lost 6 months back. The findings are prima facie, in contradiction to the evidence on record. I can understand suspension, but please see, So at least,
Assuming it's an erroneous order, even then we should not interfere. Unless we find a complete pervert order going completely beyond jurisdiction, where the High Court.
This is prima facie in my respectful submission, Once the High Court records a finding which is contrary to the record, then what more perversity is required, with all due respect. And please see.
We have heard and seen the counsel for the petitioner.
And 2 unidentified person, the High Court records he has not named. I was not actually knowing him.
That is the one.
He came in Elantra car, That Elantra car he borrowed, that witness evidence is there.
The impugned order, that the impugned order pertains to suspension of sentence and grant of bail during pendency of criminal appeal. We are not inclined to appeal with the same. Especially.
And this may not be treated as precedent, Now the police officers are in line. At least my lords may say that, They may not get the benefit of parity, If at all my lords are, my lord, not intervening, my lord, because of the rules, my lord.
It goes without saying that such a prayer, if any made by the who are accused who are police officials, or shall be dealt with by the High Court as per their own merit.
Please.
High Court has already rejected.
14 and 15, my lord. 15 is. No, the other police officers have not come. Only one, and he has withdrawn. My lord, only one. Only one. That is Kirit Paladia. He is not a police officer.
Police.
No, my lord. Superintendent of police, his application is.
No, that has been turned down.
No, it is
The
only
High Court made
the
a.
police inspector, my lord, not the superintendent of police.
The superior police officer, the constable's bail were granted.
2 AM लीकेज वारीज ने नींद चुरा ली, इसलिए स्टे फ्री सिक्योर नाइट्स काफी एक्सेल और डबल एक्सेल पैच ट्राई किए। द स्टे फ्री सिक्योर नाइट्स 2x जल्दी एब्जॉर्ब करे और सिमिलर प्राइस पर ये लॉन्गर एंड वाइडर है विद 2x बेटर कवरेज। स्टे फ्री सिक्योर नाइट्स 2x जल्दी एब्जॉर्ब करे।
Please, my lord. My lord, this is a case where petitioner is seeking his right of hearing on the bail application. My lord, what is happening that bail applications are being filed by the litigants, and that is keep on adjourning without taking on the roster because of the heavy roster or any other reason. We have the compilation of इधर से दे दीजिए एक बार ये देना। दे दो उधर। My lord, we have the compilation of various cases where such type of practice is being done, my lord. Please, my lord, I have the list. I have prepared on my own. It is not the list of compilation of all such type of cases. But suppose the case is at serial number 3.
Sir, basically, I'm to report. So, there is a slightly unusual prayer made in this special petition. It seems that the petitioner has approached the High Court for grant of regular bail. The petitioner has approached the High Court for grant of regular bail in a case registered under section 115, 190, 191 in bracket 3, 324 in bracket 5, and 351 in bracket 3 of the BNS 2023. The petitioner was arrested in that case on 11th August 2025. In bail application, we approached the High Court for grant of bail and his application came up before the High Court for hearing on 8th December 2025. It was adjourned to 20th February 2026. That is for a period of more than 2 months. The petitioner then applied for preponement, but wide impugned order dated 22nd December 25. His prayer has been declined on the ground that the bail application of his co-accused has already been dismissed. Next paragraph. During the course of hearing and on a query by this court, Komal and senior counsel for the petitioner submits that there are numerous bail applications pending in the High Court of Punjab and Haryana at Chandigarh, where matters are adjourned where the dates are being given months after. And as such, the bail applications are not being decided for a long period. On a further query and on an illustrative basis, he has submitted a chart of some of the bail applications which are pending since October 2025 and are currently adjourned to since May 2025
Right.
and are currently adjourned to different dates in the month of March 2026. You are for the state.
Yes, Your Worship, I am appearing for state.
It's not your fault, maybe.
Yes, yes.
Your fault may be that because you might be taking date or you might not be producing the record. But this is not the way the High Court should deal with bail application.
Please, Your
If you don't want to grant bail, you reject it. For 6 months, for 1 year, you don't decide the bail application.
My lord, I have given the suggested measures also, where the state is seeking time for filing status report and on any other, there are various reasons for which the bail applications are being pending. There can be mechanism, my lord, because 7 days time is always given in regular bail in High Court. Within that period, they should file the status report so that it cannot be adjourned. Because once adjourned, then it goes after 3 months.
We had introduced a system there that when you file the bail, we don't know now, you file the bail application, you will give an advance copy in the AG office, and when after a gap of 1 day,
Yes.
the bail will be listed and the IO will remain present in court.
Earlier it was being listed, but now.
Of course, now with the hybrid system, the IO can appear even online,
Yes.
but the bail application could be decided the very third day.
Yes, yes, but now it is listed after 7 days. And even within 7 days, no reply, no status report, no.
And that's why when we ask for the disposal, only these bail application disposal is shown.
Please,
The regular matters are still pending there. All 1985, 86 RSAs of criminal appeals, everything is pending.
please. It directly affects the liberty of the litigants.
Next paragraph. ये सारे सर्विसेज से जाते हैं ना ये क्या इन्होंने लाइफ में कुछ प्रॉब्लम At page 22, you can't blame the judge on a request made by counsel of the by the petitioner.
What is happening in some of the case is not being taken up. Thereafter, the counsel check the list. Then what is that on the request of the counsel adjourn and status report is awaited. There are also some of the cases. I have given 7, 8 suggestions, my lord, how it can be mechanized or improved, madam.
The biggest problem is that there is no orientation, there is no training system, there is no sensitization program of, after all, they are high court judges, they must themselves realize it.
My lord, I have given the copy.
क्या लिखा है भाई? हाँ. ROPs have also been produced in order to show that how the matters are being adjourned repeatedly, how the bail matters are being adjourned repeatedly. Next paragraph. All that we wish to observe at this stage is that we are extremely disappointed to see as how the prayers pertaining to the liberty of individuals are being dealt with. It may be true that the dockets are very heavy, and there are other matters which do require prioritization. But amongst the miscellaneous matters, nothing can be more important than the decision of the fate of, nothing can be more important than deciding the fate of the prayer to grant or refuse bail. Next paragraph. We expect Honorable Chief Justice of the High Courts to take some remedial measures. इससे पहले एक पैरा डारू कर दो. Almost shocking. Don't say shocking. It is equally disturbing to know that in the Patna High Court, bail applications are not listed even for preliminary hearing for months. And more than 14,000 to 15,000 matches are pending. One of us, मेरा लिख दो, vividly recollect various matters coming to this court only for seeking direction only for listing of their bail applications before Patna High Court. We have no reason, next paragraph, we have no reason to doubt that Honorable the Chief Justice of the High Courts are cognizant of such prevailing conditions where the High Courts unfortunately are not even able to decide bail applications on time, within a reasonable time. This is happening despite the fact that on occasions, this court has indicated timeline for adjudication of such type of matters where there is an inbuilt urgency, keeping in view the very nature of a relief sought. It seems that those orders passed by this court have not been able to bring the desired sensitivity as a result of which, due to which, the high courts have apparently not evolved any robust mechanism for time-bound adjudication of the bail matters. Next paragraph. We are conscious of the fact that listing and prioritization of the matters for the purpose of listing is the exclusive prerogative of the Chief Justice of the High Courts, they being master of their respective rosters. So, however, if the people are languishing in jail, semicolon, their bail applications are not being even heard, and they are completely in and there is a complete uncertainty as to when will they be able to know the fate of their applications, comma, it seems that this court is under a bounden duty to lay down certain mandatory guidelines. However, before we do so, we direct the Registrar Generals of all the High Courts to send complete details of the anticipatory and regular bail applications pending in the respective pending in the respective High Courts, along with the date of filing, comma, date of decision, or the next date of hearing. All the bail applications, such details shall be furnished, comma, for the time being, in the respect of all the bail applications which came to be filed on or after 1st January 25, filed on or after 1st January 2025. So, bail applications filed prior to
आंधी आए तो पर्वत बन जाऊंगा,
आग लगे तो दरिया बन जाऊंगा।
भूख लगे तो रोटी बन जाऊंगी।
ये कर पाएंगे क्या? इनका तो पता नहीं, पर उसने तो कर दिखाया। कोटक फ्लेक्सी कैप फंड 15 सालों से मार्केट के अप्स एंड डाउन्स में फ्लेक्सिबिलिटी के साथ लार्ज, मिड और स्मॉल कैप में इन्वेस्ट कर रहा है, जिससे इन्वेस्टर्स को लॉन्ग टर्म इन्वेस्टेड रहने का हौसला भी मिलता है।
म्यूचुअल फंड निवेश बाजार के जोखिमों के अधीन है। योजना से जुड़े सभी दस्तावेजों को ध्यान से पढ़ें।
the case in hand, we find that the bail application filed by the petitioner is coming for hearing on 20th February 2026. We request the Honorable Judge to decide the same on merits, either on the date fixed or prior thereto, if an application or prior thereto, provided that the petitioner seeks preponement of date. Next paragraph. Within 4 weeks, post the matter for further consideration on so and so day. उसमें लिखना, all the state governments are directed to fully cooperate with the high courts for early and time-bound adjudication of the bail applications, stop prayer for suspension of sentence. The High Court shall sentence of the states should be ready with the relevant information as and when the bail application is listed for hearing, provided that a copy thereof has been handed over to, has been submitted in the Office of Advocate General and or the public prosecutor at least 3 days in advance. At least 3 days in advance. In such like matters, the investigating officers or the authorized officer can be permitted to appear online also. Next paragraph. The Registrar Generals of the High Courts are further directed to circulate disorder amongst the honorable judges of their High Courts who they, our fervent appeal to them for expeditious disposal of the pending bail applications. Next paragraph. The Honorable Chief Justices are also requested to revisit their roster stroke listing arrangements, and wherever they find that there is a mismatch between the total pendency and the bench allocated for deciding such matters, comma, they may consider the desirability of listing the bail matters before. They may expand the roster for listing of the bail matters. Post the matter on so and so date.
May I make one more submission, my lord? My lord, in cases of suspension of sentence, sometime what is happening that custody is more than 7, 8 or 10 years. suspension of sentence bail application either pending or disposed of by listing the appeal. But appeals are also not being heard. And 7 years custody, 10 years custody after conviction of total, my lord may also call the record. The appeals in which custody is almost.
Say, Dr. Pankaj, that there are the system that has its own difficulties. If you start taking your only criminal appeal, the matrimonial appeal, the matrimonial cases, the other admission matters, academic matters, those get delayed. So some balancing has to be done.
There is no doubt that that is heavy roster, but 10 years custody is something.
No, undoubtedly, we don't, we strongly disapprove rather, if there is custody of more than 10 years, even normally in a case of life sentence, barring a few cases where death sentence is there or the crime is so heinous that life imprisonment means that he has to spend 40 years or so. In such cases, there is no question of granting bail. But then you pass an order, dismiss it, matter ends. Somebody would have, they have a right to go in appeal, let them come. But keeping pending is what is bothering us. You pass an order, that is prerogative of the judge. Whatever order they want, they let them pass. Right, let us see what.
Items 36, 37 are those Bengal SRs. In the sequence, it was supposed to come after 16. So is that being taken up?
We'll take up to.
Because sequence was issued this morning. It said it's after item 16. Items 36 and 37.
After this.
Fresh matters.
1 or 2 fresh matters are left.
Yes.
After that.
These are fresh. 36, 37 are fresh matters. Bengal SIR.
Those are will take with us.
I'm great.
Just a minute, only 2 matters are left.
Very well.
I'm great.
Yes, item 40.
Yes, my lords, I appear for the petition. One.
You can argue from there now.
Only difficulty is, my lords, the elections are slated to, my lords, on Friday. My lords, my objection was dismissed only on 22nd. Also on 23rd, immediately I have moved the High Court.
Pending.
Also immediately before the High Court, I have moved, my lords, the very next day.
You want to oust your opponent at the stage of nomination itself.
No,
You don't want to face in the election.
no, my lords, the only difficulty is that, my lords, I have moved the High Court immediately on the next day. My lords, no hearing has been given.
If you win the election, then he is out by itself.
That is it.
Then
May I only make one request, my lords?
23rd options open.
Yeah. I'll withdraw this petition. Its only request is that this objection I may be allowed to raise at an appropriate stage.
You are entitled to.
Because the difficulty I'll face otherwise is that the order of the returning officer which is against me.
Counsel for the petitioner seeks and permit to withdraw this petition with the liberty to raise all the, to take or to raise all the contention at an appropriate stage. Order to court.
Very well. I'm highly grateful.
Item 41.
Lordship, almost more than 90% encroachment has been removed from the government and forest land, Lordship. This fact is already acknowledged by the respondent number 2 to 5, Lordship. May I read, Lordship, annexure P5, Lordship? Page number 36, Lordship.
But why not remaining 10%?
Actually, Lordship, but there is a one beam, Lordship.
My lords, I am appearing for R1, my lords, for Miss Chandel, my lords. My lords, my only 2 submissions, my lords. The first is, my lords, in the month of May.
That pillar of the house.
My lords.
Beam.
My lords.
Normally they don't construct pillar in Himachal.
My lords.
But that beam or whatever support to the roof.
My lords.
That is coming in the government land.
My lords.
And if that is removed, the entire house will fall down.
My lords, they were new while they were constructing, my lords.
Like they knew.
Who is he, Lordship?
They were new the consequences of my lords. Still they constructed, my lords.
Who is he, Lordship? In which capacity he is appearing?
My lords, again, in the month of January, my lords, the petitioner again encroached the government land, my lords.
That we will.
They are using.
₹40,000 crores. And the investigation is ongoing. This is, of course, my lord, bank's public money.
40,000 crore. But
40.
there are two, three disturbing things. One is that, are you presenting CBI also?
Yes, yes, my lord. CBI, ED both.
They have
Now,
filed,
CBI says that on the basis of the complaint received from one bank, FIR is registered, matter is being investigated. Meanwhile, from other financial institutions also, complaints have been received. Now they say we want to register separate FIR.
We do. No, my lord, what we have done is I have taken specific instructions on that. The first FIR came from the State Bank of India. Thereafter, my lord, other banks also intimated us about their, my lord, alleged siphoning, etc. That is also now included, and it's a part of, my lord, the investigation. Because we cannot have separate FIR.
These complaints, are these not, these not amount to constituting a separate independent offence? Nature of the offence may be same.
Yes, my lord.
Nature of the offence may be same, but in terms
The
of
transaction as, my lord, used
the
in the
complainant
judgment.
is different, the time of transaction might be different, the manner of transaction also might be different. Ultimately, so therefore that will constitute an independent offence. Why are they not registering those?
Lord, that can be done. We will examine. Possibly, my lord, there was a consortium lending. If that is so, then perhaps, my lord,
If in the case of consortium and the lead bank has made a complaint, understandable. That will, provided that the lead bank says it is for and on behalf of all the banks.
No, my lord, the lead bank says only for it. That's correct. No, we will examine that, and we are not averse to registering separate offences if these are separate severable transactions. There is no difficulty.
actually, my lord, in this case, this FIR has been registered in 2025. The Bank of Baroda's audit report came in 2020, in which they had detailed the manner in which the funds have been siphoned out, etc. So the bank unfortunately did not, for 5 years, did not lodge this complaint with the CBI. Only in 2025, they seem to have lodged that complaint. And till today, my lord, only after your lordship issued notice, they have effected the first arrest in the matter day before yesterday. Till today, my lord, in a bank fraud of this kind, this is the largest corporate fraud in this country.
Now that it has been brought to our notice, and we will continue to monitor it.
Yes.
And we will ask them to file status report.
That's what we want.
That will have to be done.
That's what we want.
Lord, may I make a submission? Lord, I appear for R5. There are, my lord, 5 FIRs by CBI representing, my lord, a large number of banks. There are 3 ED, my lord, ECIRs based on that. There is 12,000 crores worth of attachments, my lord. There are, my lord, more than 100 summons.
The first arrest in the matter day before yesterday.
It's not nobody
Till today, my lord, in a bank fraud of this kind, this is the largest corporate fraud in this country.
Filed by ED,
Now that it
they
has
set
been
out, my
brought
lord,
to
all
our
this what I'm
notice,
saying.
and
This is
we
what
will
they're doing.
continue to
And
monitor
they
it.
say that, my lord,
I
they
will
are
ask them to
needed
file
to
status report.
That's what
Lord, etc., etc.
That's
for them.
That's what we want.
As far as Lord, I am concerned, I had a proposal. I appear for R5. I am not, my lord, there are, my lord, 5 whatever, my lord, FIRs by CBI. I have a representing, my lord, a large number of banks. There are 3 ED, my lord, ECIRs based on that. They say it is siphoning. There is 12,000 crores worth of attachments. There could be business losses. There are, my lord, more than 100 summons.
The first arrest in the matter day before yesterday.
It's not doing
Till today, my lord, in a bank fraud of this kind, this is the largest corporate fraud in this country.
Filed by ED,
Now that it
they
has
set
been
out,
brought to
all
our
this what I'm
notice,
saying.
and
As to
we
what is
will
what they are doing.
continue to monitor it.
Say that, my lord,
I will ask them to file status report.
That's what we want.
etc., etc.
That's what we want. That's what we want.
As far as Lord, I had a proposal. I appear for R5. I am not, my lord, there are, my lord, 5.
Lord, I have something to say.
Whatever, my lord, FIRs by
I
CBI.
have taken
Check to my lord, the Chief Justice, my lord, taking a call on the government.
Lord, only a minute, my lord. We, the banks, Lord, conducted a forensic audit by an outside forensic auditor, my lord. And the forensic auditor has said that there is siphoning and other things, my lord. My lord, we may perhaps not be able to, my lord, compound these offences, my lord, even if there is a readiness to pay.
Mr. Solicitor, in spite of what you are submitting, see paragraph 27 of the CBI report. You are dwelling on 17 capital A again. if the forensic auditor says that there was a breach not of loan terms but of collusion, then what is the question of stopping the registration of RCs in view of taking sanction? These are
Well,
clear
this point-
operations. Please examine.
I will answer my lord's question. I have put it to the government, my lord, to the CBI.
23
That was in fact my next.
Yes, your lordship's question is very pertinent. My lord, the public officials are also under the investigation. They are also under investigation. Number two, the respondent number 5 and is possibly respondent number 5, the individual, filed suits in Bombay High Court, and there is, my lord, an injunction granted not to act upon the forensic audit report, my lord, on the ground that the person who signed the forensic audit report is not a member of the Institute of Chartered Accountants. I am not going into it. Banks have filed an appeal. Appeal is heard and the judgment is reserved. My lord, I appeared for the bank as well.
I appeared on, that's a completely different issue.
Different thing, my lord.
We are entitled to say a report is good or bad.
I'm not on the merits.
That matter has been argued, so we'll wait for the.
Yes.
Your judgment will come soon in a week or 10
Even an
days.
injunction has to be subject to 41 of the Specific Relief Act. You can't get an injunction on registration of an
Injunction
FIR.
perhaps may not apply even
Absolutely
to
not.
an independent
But we are
investigation.
not arguing that case here, my lord. Question is, there is a report which, my lord, declares me as a fraud. Report is issued by a person who is incompetent to do so. So I am questioning that, that's
Mr.
all.
Rodriguez, there are two things.
Yes,
If there is an intention to
Yes.
siphon the public funds
yes,
from X to Y, Y to Z.
yes,
From the very beginning, and if that has actually happened, then probably the solicitor is right in
Yes.
saying that this kind of offense can't be merely because you are willing to pay.
agreed, my lord, agreed.
That cannot amount to condoning.
Absolutely
Date
right.
of birth
But
of
my
the
lord, it is
candidate
my
may
case.
be
There was
submitted
never any
apart from,
intention. We
the
have done
Vadyamic
business, my lord, for
passing
40 years.
That is what precisely.
Yeah.
Can you grow your wealth anywhere, anytime, without the right partner? Imagine expanding your business to London while setting up a family office in Singapore and investing in Dubai. Standard Chartered's unique global network and deep local insights give you unparalleled expertise anywhere, right now. Now's your time for wealth.
Stance. I have cooperated. I will cooperate. Whatever else your lordship will direct, we have.
What you are suggesting, Mr. Ropi, that
Well-
can be, that can only be probably from your side. It
Yes.
will come. Provided that after thorough investigation, someone says that it was a case where the default took
Which is a
place
snapshot.
for the reason
Now the
beyond
number
your
of days
control.
That's
left
right.
for the final publication.
No problem.
It was not misappropriation, misapplication or something. But it's a deliberate siphoning of.
But it can happen.
Number of
It
days
can
left
happen,
for
my
final
lord. People do
publication
go
of electoral
bankrupt.
roll
Even
is
it's
11
not that
days,
every
and
bank,
that's
my
up
lord,
till
has
14th
taken money and run away.
2026.
I just want to
No,
comment.
no, even if we ignore
If your lordships will just permit.
the audit report of the bank,
2026.
the
Number of
ED
voters
in their
categorized
counter
on a
affidavit
draft
is saying
roll as unmapped
that they have
is
found
32
evidence of
Number of
forged
voters
bank
categorized as
guarantees
logical
being given by
discrepancy
them.
post-draft poll
They have-
Then
publication
itself is a
is 126
independent
crores,
offense.
Therefore, I
which is
said it may
20%
not
of
be
the electorate
possible
of West Bengal.
Forged bank
compound that
guarantees,
offense for
siphoning out
somebody.
to all
This is
these
just to
tax
give you a,
havens.
idea.
At least
In
26,000
December
crores has
2025,
been
which is
siphoned
41
out
days,
to these
so
tax
far
havens
they've
like
held
Mauritius,
88
etc.
lakh hearings
Not
with
a
respect to
single
88
penny has
lakh
been cuffed up.
voters,
They have
which is at the
declared
rate of
bankruptcy in
1.8
all their
lakh per day.
companies.
The number of
1
hearings
lakh
pending is
78,000
approximately
crores of
63 lakhs.
outstanding
And
dues
this
in
will
these
mean
companies.
that
1
if
lakh
they are,
78,000. The only amount recovered in bankruptcy proceedings is 15,000 out of 1 lakh 78,000. Most of the money has been siphoned out. That gentleman, my lord, who owns all these companies, he has not been arrested till date. Till date, my lord, the main person, the kingpin of this whole scam has not been arrested. Only they arrested one officer of this company 2 days ago, day before yesterday. Only because of this matter coming up.
Number of micro
No, not because of that.
Comment, Mr. Solicitor, but then it's a very serious.
Lord, we are before your lordships and we will have to ensure that your lordships' conscience is satisfied that the investigation is impartial and going in the right direction.
Today we are not passing any harsh order because
it's a very, very limited role
someone
which
may
they have
not
on
take it
election
that
day.
our order
But
has
not
caused
the
prejudice.
activities which have been
But we
deployed right
expect
now,
that your
which has
agencies
been
must
given to
act
them at this
fairly,
stage. Number of approved
independently
documents
and very
rejected after
swiftly.
hearing
We
stage
would like to
commenced.
have status
Now, this is
report
one of our
every month
grievances.
in
the
4 weeks,
panchayat
they must
residence
submit the
certificates,
report and
the
let us see how
family
you take
registers,
the
the domicile
investigation to
certificates,
what, where to
Aadhaar
take
card,
conclusion.
Please,
So much, such
and
a
land
huge amount has
allotment
been
certificates.
siphoned.
It is.
None
Then
of
we are-
these
Lord, this
are
is not
by
correct.
themselves
This
being
is
accepted.
absolutely not correct.
And
Just
despite,
banding figures
orders
like
of the
this.
court.
Just 2
And then,
points.
Milord,
It's
we have
absolutely
went to
incorrect.
I just want to
meeting in 4
clear
and
the
5
impression.
hour
One you are
queues
presenting.
I'm
over there.
appearing for
Now,
respondent
please go
number
over to
4, which
page
is the
2,
group of
para
The companies.
Here, Manoj, I might
We
just mention
formulated
that
the
the service,
specific
because the
point.
impression carried, I think last
Now,
time when
the
your
first
lordship passed the
suggestion
order, was
is
that service was effected and we were not
non-statutory
appearing.
category of
In fact, we
logical
have received the papers
used
only
to
after the
issue
31st of
notices to
January,
1.36
because I don't know
crore,
which address they went to,
otherwise
etc. But anyway, now we are on record,
Now, this
we've
is our
placed our thing,
request.
we'll take
Direct
some
the
time to put in
ECI
our
to
response.
That's it.
upload
I'd
the
be grateful for
reasons
that. The
of
second
each
point which I
elector
want to
flagged
mention,
as
because a large
logical
number of figures have
discrepancy,
been bandied about,
cases
that in the
1,
last
9
5 years,
on the
two of the
ECI
companies,
website.
Reliance
May I request you
Infrastructure
to
and Reliance
directly go
Power,
to page,
have paid back a
we will
total
explain
of
this more fully,
20,000
but just
crores
go
of
to
rupees.
page, appendix
20,000
1
crores of
and page
rupees.
8
Now, this is a very,
of the
very
same
important
But the
element.
amount is 1,78,000.
Now, I'm
this-
just
What
giving
I'm
you an
trying to
example.
get,
This
what
is not
can
correct.
people see, Milord, that those
This
figures
is not
are
correct.
valid.
Milord,
What
5
we are trying
minutes.
to
Absolutely bad.
project over
Please
here
go to
is that
appendix
when a party has
appendix,
repaid 20,000 and these two
Page
companies are
11,
now virtually debt free. I mean, there will be
Yes.
some,
Now,
obviously
pursuant
some
to your lordship's
requirement for working capital,
Thousands of
etc.
This is
shareholders.
what
But
is being
it's
put
over,
up.
Milord, something like 50 lakh
But, as
shareholders,
you will
small
see,
investors are
so
there
the name
as
of
far
the
as these
elector
two
is
companies
there,
are concerned
age, gender,
on the aggregate.
and then
So
the
this is,
category
Milord, obviously a group
says
which
PM,
repays the amount.
which is
Now we will,
discrepancy
there,
in
as your
magnitude.
lordships may have seen
But
from the,
person
we
doesn't
don't have the
really
advantage
know
of the report, but we do have the
when this
enforcement
is put
directorate
up on
affidavit which
the
has been
reasons
done.
are not
Where there's a
indicated
series, the
over here.
affidavit
So
says
what
that
is the
there's a
reason for
series of
this particular
steps and measures which have been taken
in
in the
mapping?
last 6 months.
Yes.
So there's a relentless, my lords, effort. We are trying to ensure that the payments are made and there is no question, my lords, as far as this suggestion of siphoning, etc.
Just one company.
Anyway,
Not
we
only
will-
one
we will
aspect.
bring- and therefore, my lords,
lag as far as
I
those
think
notices
the
are
suggestion which
concerned.
was made
So
by
we are
Mr. Roti is a
suggesting some
valuable
short
one.
reason should be
Most of the,
indicated on
you
this
see
as
the
well,
enforcement
because it will help
directorate
the process.
affidavit also,
People will know
that's
why
all
are
that we
they-
have.
why are
They have
they
talked
on
about
that
public funds,
particular,
etc. being siphoned
list?
away or being
What's the
removed.
reason for the list?
Now that doesn't seem to be the correct impression, which the enforcement directorate, but they are entitled to their view. So therefore, if there is some solution which can be found to bring this out, at least it reduces the issue, because that's the primary
There are
purpose
two
of it.
So let us see that.
Let me respond, my lord, on two aspects, my lord. Number one, Lord, in the forensic audit report, Lord, it has come out that in some cases the money is taken as a loan from one bank to repay the another bank. That may be, my lord, I'll have to check up, my lord. That may be the way in which, my lord, this is repaid. Second, Lord, this suggestion placed before your lordships may not be utilized in other forums that now Supreme Court is considering constituting a committee which will go into what is payable and how to
For
pay.
example, page
We are-
9.
Because there are suits and petitions pending.
Mr. Shashi, we are not constituting any committee today.
Yes, Manoj.
We are still expecting and we are hopeful that
Because this
CBI
will
and
certainly
ED
help.
will
আমি কোনো ভেদাভেদ করি না না
My note, just go to page 2. I'm going to now build on this point.
page 2.
Yes. So on page 2 of the note, 5A1, I have made the point, then your lordships will see upload reasons is what we suggest. Now, number 2, in 5A2, direct the ECI to withdraw all notices under the category which pertain only to name mismatch. Now, look at this. Yeah.
Page 5, page 5. 5.
Nothing to say.
5A.
Yes,
This A then clause 2.
yes.
Where you are A to.
The name mismatch.
Are you referring to the cases, say
Yes.
for example?
Yes.
Just on illustrative basis.
Yes.
So for example, one person writes Datta.
Yes.
Somebody may define, may spell it as D-U-T-T-A.
Correct.
The other may spell
Yes,
it
absolutely.
D-A-T-T-A.
Absolutely. Yes. Yes.
That is one part.
Yes.
Similarly, Banerjee,
Yes.
Bandyopadhyay, and
Yes.
similarly in Sarma,
Yes.
somebody may write SH,
Yes.
somebody may, many of them write SARMA.
Yeah, so your lordships have exactly anticipated what we have set out in paragraph 7A. In fact, we've given Datta, Ganguly, Roy and Ray as examples. But we've given actual examples of what is being faced at page 8.
But
Now,
according to you, you see,
look at, sorry. One is
tell
name
them to
mismatch.
withdraw the notices will be, is something very impractical thing, because notices have been issued.
No, I'm suggesting. My suggestion is that our estimate, it's an estimation, that in the logical discrepancy cases, please go to paragraph 7A on page 4. Just go to 7A of the note, page 4. A majority of the logical discrepancy cases, more than 50%, which is around 70 lakhs, are cases of minor name mismatches and spelling variations. And we've given the very examples which your lordship. Page 4 of the note. 7 subsection
Yes.
Para A.
A.
A majority of the logical discrepancy cases, more than 50%, are cases of minor name mismatches and or spelling variations, and your lordships knows. Now we've given you an actually of actual electors. Please go to page 8. This just builds on the point which your lordship made. Please go to appendix 1, which is page 8 of the note.
Page
8. Now, your lordship has it. So now Mr. Chirag Tibrewal, his discrepancy was father's name mismatch. My father's name was Kumar in the middle. Your lordship has it. Last column. My father's name has Kumar as the middle name in the 2025 SIR, which was not there in the 2002 SIR. I have been served a notice and called for a hearing on 27th January. Look at serial number 5.
3, just see 3.
All right, 3. Well, let's please see, this is Ajimuddin Khan. Now see what has happened in his case. Father's name is shown as KHA, Alauddin Khan, in the Bengali, whereas it should be Alauddin Khan. Because you see, from the one from Bengali into English and vice versa, you can lose this. Yes. This may be software.
Illustration number 3 may be slightly difficult, because here you are saying Azimuddin. Azimuddin is.
No, it's Alauddin. Father's name, father's name.
So the spelling mistake is, or spelling difference is in the name Alauddin Khan.
No, that's his father's name. Please just see.
The Chandramatra there.
Yeah.
The form in Bengal.
Okay. Khan has become you but not.
Yes.
But
And this is not in other states.
okay.
This is dictated.
The 2002 electoral roll was in Bengali. So when they translated it for this purpose.
Out can be. All right. What is your solution? Because then we are also thinking.
No, because there are two ways of looking at it. One is, look, this name discrepancy, my lords, which is the bulk of it, is cramping even the available time, which is just a few days. So these name discrepancies, my lords, should not be within this logical discrepancy to knock out people from the electoral roll, because look at the inconvenience. Look at one of those notices.
Your solution, Mr. Dwivedi, have you think about it?
Actually, more than 80 crores hearing have already taken place. Few more which are left.
No. What about this kind of discrepancies which are not even a spelling mistake, which are only on account of how you speak in the local dialect? This happens pan India. It happens in Haryana also. It happens in Punjab also. It happens in West Bengal. It will happen in Tamil Nadu also.
Yes. So, We don't have instruction,
Because-
thing chart given to us just now, my lord, it's not there in the IA, etc. But ordinarily, what my instruction.
Suppose, Mr. Diwan, let's find out.
Because name mismatch
Well,
people should not be
I
purged.
don't want to interrupt.
from the electoral
I don't
roll.
want to interrupt.
Please don't purge people.
Mr. Sibal, you are unwell today, you better take rest.
I am going to, but I don't want to interrupt your lordships will remember, Mr. Dwivedi made a solemn statement, then where is this kind of discrepancy, we're not going to bother about it. Your lordships will remember that. He said if it's a question of spelling this, I'm not going to, this is not something that will be.
Bengali, if you were in Bengal, Mr. Dwivedi, you will be pronounced as Dwivedi. B will become B.
And you will also be ousted.
Yes, then you will not be purged.
Language doesn't have a war.
Gujarat will become.
Bengali language doesn't have a war. Or yeah.
Instead of my brother being addressed as Vipul, they will address as Vipul.
On this aspect, my lords, may I just, sorry.
But my name, there will be no mistake, because it's a basically Bengali name.
Sir, it may be, sir. Sorry, sir.
With your
Because
broad
you-
permission, my lords, could we just have an insight over here from? Yes, please.
5 minutes.
If you allow me, sir.
So, go ahead.
ট্রিং ট্রিং ওমা মেসেজ মেসেজ আমি আপনার মেশোর কাকার নাতির পুতি বিয়ের কার্ড মেসেজে পাঠিয়েছি ডাউনলোড করুন আর আশীর্বাদ করুন।
আমি তো তোমাকে চিনিও না, তাও বিয়ের কার্ড খুলবো? আমি মূর্খ নই।
আরে জবাব নেই মামা। ইউপিআই বলে যদি কেউ অচেনা নম্বর থেকে ফাইল বা লিংক পাঠায় তাতে ক্লিক করবেন না, তাকে বলুন আমি মূর্খ নই। জান, আপনিও কারো টেস্ট নিয়ে দেখুন।
Bangla and who are well conversant with the local dialect.
Yeah.
And they scrutinize these, just scan through this and tell the commission that this is here only a local dialect mistake
Yes.
and not any identity mistake.
Yes.
That will help them.
No, it will help them, but it's apparent. my lord.
Oh, Johnny.
Actually,
Apparent in some of the cases on illustrative basis it may be, but it will become humanly impossible for you or for us to go through and to.
Lordship,
May I explain you, sir?
Give me time till tomorrow day after, my lords, then I can get back.
May I explain you, sir?
Because in my view.
Because I belongs to that state. I am a.
Can there be any doubt, Madam?
No, sir. No, sir. I am very grateful, sir, because of your kindness, my humble regards to my Honorable Chief Justice, Mr. Bagchi and Mr. Panchali also. Panchali ji also. Thank you very much. And my humble regards to Mr. Dwivedi and others, my opponent lawyers also. Sir, the problem is, always our lawyers fight for the case and they're fighting from the beginning. We are also. But sir, when everything is finished, when we are not getting justice, when justice is crying behind the door, I quote Rabindranath Tagore, then we thought that we are not getting justice anywhere. So many times I have written 6 letters to Election Commission, including all the details, but no reply, sir. I'm a bonded labor, sir. Maybe I prefer that. I'm a very less important person. I prefer that. Sir, I'm from a common family, but I am not fighting for my party.
Madam Mamata, sorry for interruption. The state of West Bengal, in its own right, has filed a petition, right? Today, of course, you are also coming in your individual capacity, but state of West Bengal, in its own right, there is nothing wrong in that. State of West Bengal has also filed a petition.
State of West Bengal has not.
One of the best counsels in the Supreme Court, fortunately, are there to not only are to represent the case of the state. Mr. Sibal appeared on that day. Today also, incidentally, Mr. Diwan is there. Then in the other matter, Mr. Gopal is there. The best of the team, the legal team in the Supreme Court is there to assist us in the matter. Mr. Sibal, though slightly ill,
Sir, if you allow me 5 minutes only.
Now he is there.
Only
On-
5 minutes only.
We will give you, for not 5, we'll give you 15 minutes. We are only pointing out that on 19th
Yes.
January, when the matter came before us, Mr. Sibbal very eloquently he explained the procedural difficulties which the state was experiencing and where the state had some genuine apprehension for exclusion of the bona fide citizens of the India, citizens of West Bengal, the residents of West Bengal who are citizens of India. So therefore, those directions, the direction which Mr. Diwan just read out were issued. Today, in your petition, some additional issues are
Yes,
being
sir.
flagged. Absolutely right. Issues are being flagged. Every problem has a solution. So we must look toward the solution in order to ensure that no innocent citizen is left out. This SIR is based upon only on 3 grounds. Dead persons excluded, no difficulty, neither you will want, nor anybody will plead for the dead persons. Similarly, the persons who are disqualified to remain for any reason, somebody is convicted, whatever may be any ground in the law, you will not plead their case. Similarly, those migrants, the word is migrants is also one of the ground. Those who have left West Bengal, even you will not plead there. But the genuine persons must remain there. Now, among the genuine persons, one of the ground, as Mr. Diwan has today flagged, and rather we are thankful to you also that in your petition now this issue has been raised, that because of the local dialect or because the manner in which the Bangla people will proudly pronounce a name or it, because of that, and this all because nowadays AI assisted computerization, that you are speaking Datta and they are recording something else. If this kind of things are happening, we will find out a solution. They will have to find out. They can't. They will not like to run away from that responsibility. That by virtue of this kind of mistake, the genuine and bona fide person must not be excluded.
Sir,
So,
what happens
just
now?
only one
Sir, what happens now?
permitted before they could open millets. Insofar as
saying
the
this, that-
Election Commission of India is concerned, I represent. In that matter, so far we have not been served with any pleadings. We are clueless what their grievance is. If it's been there, if it's served on us, a week's time given, we'll get all instructions, we'll place it before your lordships
No, week's
and
time
look
will
forward
be-
to any genuine difficulty to be redressed.
Week's time will be too late.
So be it, millets, let it be on Monday.
Week's time, let them.
Let it be on Monday.
Sir,
Because millets were clueless what the grievance is.
sir, this is not.
I understand.
Item
This is-
21 is
Please
the-
allow me, sir.
It's a reply in
It has not
21.
been served.
You are right in saying that you have not been even given copy because
No.
the matter is coming first time for hearing.
Indeed.
The only thing is that since all this entire procedure has a timeline, at that timeline, we had extended on 19th January for another 10 days.
True minutes.
But that 10 days time is also now, because they rightly pointed out by Mr. Diwan that out of that extended period, only 10 days are left. 4 days are left. After those 4 days, only 11 days are left. So this being a timeline, we can't grant you the luxury of 1 week notice or 2
Millets on Monday, so that
Sir.
we'll come to know what the grievance is and we'll
Sir.
suggest or place before your lordships the remedial
Sir,
measures.
please allow me to finish my point, please.
In principle,
Yes.
if it is happening that Roy, Datto, Ganguly, Upadhyay, anyone like this, by virtue of the local dialect, if the name is being spelled out slightly different than what the accurate words might be, somebody can say.
Precisely.
In a given case, we do not know how Tagore is also defined. Maybe somebody put the E in the last, somebody may not be putting E. But that does not mean Tagore is not Tagore.
Millets,
So you also have to
Millets,
come out with a.
what they cannot
technical
afford
way
to
out.
forget
So
is-
is the state can suggest us a way out. We will.
millets, even the field staff are local, they pretty well know all
Respected
these
Chief Justice,
differences.
sir,
Not that
I am
something imposed.
giving you the example. I can show you some photographs. If you allow me, only I want to submit, sir, I want to lay, because it is not my photograph. All the Bengali leading newspapers, it is reported. You'll be surprised to know the, sir, only, sir, my submission, sir.
No,
Sir, their SIR process is only for deletion, not for inclusion. Mismatch, not only the title, sir. Mismatch, mismap, unplanned. Now suppose a daughter after marry, she go to the in-laws house. Now why she's changed her title? Why she's using the husband's name, husband's title? That is also mismatch.
It can't be.
Yes, sir, they have done it, sir.
That's why we are.
Now,
That's
sir,
why we.
only just want to say. Number two, sir, there are some daughters who married and shifted the in-laws house. Their name also just unilaterally deleted. It is just because they shifted their houses. Sir, you will appreciate sometimes some people work some office, they go to be, they transferred other offices, they work somewhere. Sometimes the poor people, they purchase the flats, they shifted their addresses, but they are the genuine people are staying there. But because of the name of logical discrepancy, now they change the name. No, instead of logical discrepancy, when you gave order, sir, they violated, and they say it is the discrepancy mapping. Sir, can they even violate your order? Number two, sir, we are grateful. Bengal people are so happy that this court gave order that Aadhaar card will be one of the proof documents. But they said no, on with Aadhaar card. Sir, in other state, sir, the domicile certificate is allowed. Sir, the family registered card is allowed. Sir, the government housing card is allowed. The health card is allowed. The bank books means whatever caste certificate is allowed. Only they targeted Bengal on the eve of election. Sir, 4 state opposition state are going for on the eve of election. But why after 24 years, what was the hurry to do it? What it takes 2 years, only within 3 months, even when the festival season is there, when the harvesting season is there, when people are not in a mood to be in the city, they were in the outside, but they are traveling, and that time they issued the notices and all this. Sir, more than 100 people died, sir. Can you imagine? Sir, BLOs died, and they have written the letter that CEO is responsible for my committing suicide. So many BLOs are murdered, they died, and also more than 150 people died, and so many are hospitalized. Sir, because of the harassment of the people, because of Bengal is targeted, sir. Sir, you tell me why not Assam? Sir, why not Assam?
The state government, we cried foul, saying that
why not Assam?
need cooperation. They say
Why not Northeastern?
Madam has come all the way to speak something.
indeed, my lord. But the only thing is that, my lord, if it's off the record, we need to.
Madam Mamata, let me
Yes.
let me clarify 2-3 things to you.
No, this is
About the Aadhaar card,
commission.
this matter about SIR's validity issue. SIR's validity issue is being argued before us from last more than 2 months. In the main judgment, which was the first case, we have reserved the judgment. Therefore, we are not in a position to comment with regard to the credibility, credential, or admissibility, and to what extent about the Aadhaar card. That issue has been argued before us. We have reserved the judgment. But you also will appreciate Aadhaar card has also its own limitations when you will read that statute under which it is issued. At the same time, with reference to its insertion in the RP Act, what will be its value? We are yet to determine that part. You have one part. Second, you have pointed out this issue of the discrepancies part. In this case, one way out can be that you give a team of officers, the election commission can take them on deputation in the sense that those can also be part of the election commission team, verify that here it is a spelling mistake or it is only because of the local dialect that this mistake is occurring. Those must be rectified. That has to be rectified. So let us see what response they will give. We will grant them 1 day time. Tomorrow or
Sir,
day after.
No, sir. What happens, sir, ultimately, in practical, ERO has no power now. They have superseded all the power from DO, ERO, BLRO. Only they have appointed 8,300 micro observer and the role observer from the BJP ruled state, so that DO cannot clear the name. It is all micro observer can delete all the names sitting inside the election commission office through AI. Sir, earlier 58 lakhs are being deleted. Even they were not allowed to file Form 6. Sir, earlier first phase, 58 lakhs deleted. There are so many people are alive, and now they are being declared by that they are their death. Sir, the anti-women, so many women.
Madam Mamata, if need arises, we will mandate it, we will direct. Every document will have to be signed by the BLO, who are the authorized officers and who are the authorized notified officers.
Kindly see the
And
directions in the website, Millers,
don't
so
think
far as
that
the so-called
election-
micro observer.
Micro-observer is the final authority. Election Commission, WhatsApp Commission. WhatsApp Commission is saying it is only the micro-observer. Only they are deleting all the names.
Millers, they could
These-
certificate on record, except.
May I just take you back?
They are all government of India officials.
My lords,
They are,
given
My lord, in one of the matters, government is a party. Lord, let,
but the problem is that they are not allowing the people.
let the matter.
They are not allowing the
legal domain
state officials.
possibly for most of the submission.
They are not allowing the domicile certificate.
Day after.
They are not allowing the government certificate.
Let there be a direction, Millers, we should be served the copies.
May I just highlight? two
I
points?
have something.
Yeah,
to
I
say
just
about
want to
this.
highlight 2 points. If your lordship would just take up, I want to save time, so just go to my note for a moment. Just go back.
But
to
I want to intervene
There
for 1 minute, Lord, if Lordship permits, Lord. We have written several letters to the state government to give us Group B, Lord, the class 2 officers of the rank of SDM or equivalent, so that, my Lord, EROs can be appointed. That's the standard pattern, my Lord, that they should be class 2 officers because they decide vital rights papers and all.
No, that has.
Now they have given, my Lord, only about 80 officers of that rank. Rest, all of them were given who were clerks and below, who were working under the pressure of the state government. Therefore, we had to appoint, my Lord, micro observers who can assist, my Lord, in case, my Lord, they are in the confusion. So the fault lies with them in not giving us class 2 officers for performing the job of AERO and ERO. So that's the reason why this is happening. And these micro observers are validly appointed under Section 13C, read with 3.
No, there is no statutory rules.
My learned friends are not right, Lord, that they are not, we are not entitled to appoint them. If this is the state of affairs, which is not contemplated by the rules and the state is not cooperating, then there's no alternative except to appoint the observers who can assist. Class 3 officers from Anganwadi and so on, they are being given to us. So that's
And
the
this is the
reason why
communication.
assistance.
There is only one.
But they are not assisting.
There is
They are
one,
taking
one,
They are
lordships
taking
have
decisions, not
one
assisting.
side of the story. May be true, may not be true, I'll not go into it.
It's not-
There is one more petition where the Election Commission of India has filed an affidavit. So that also may be taken on record. It's not listed on board. It was mentioned by Mr. Giri. Lord, I am appearing in that matter and I have read the affidavit. Lord, that also will have some bearing, my lord, in ultimately what your lordship passes the order.
And we have highlighted all the
I just-
difficulties we have been facing, Millets.
My lord, my lord, my lord.
My lord, it is pointed out the
May I
hostility.
just
which
have
is
2
there.
minutes? I just
My lord, all
want
observers
to
are not
highlight.
A
assisting.
victim, that's all, my lord. I am saying, let us confine.
Ultimately, we
No,
will
no.
ask them to at least 2 days' time, we'll have to give
Yes,
them
yes.
to seek their response.
Sir, matter is not correct, sir.
Survey copy, Millets.
But fair enough.
Wait, Amaka-
What I'm highlighting is
There
just
is no
2 things so
problem.
that your lordship sees them.
Let me say this, Lord, there's no problem of time, my
The
Lord.
the first.
Have some buffers if there is
Arey bhai, eta
more than 1 crore already heard. And if somebody is not heard, your lordships are there and we
We
are,
will
our
grant it.
power is
We
there.
have been
to
extending
expand
time.
it by
We have been extending time. We have been.
My lords have passed a slew of directions.
My lordship,
Every
my
aspect-
lordship with my humble regards. May I tell you, sir,
Whatever they have pointed out.
my
and
opponent lawyers raised.
said that.
Sir, sir, that is not correct. That is not correct, sir.
Madam Mamata, we have no doubt about the ability of Mr. Diwan. He is one of the best senior counsel you have chosen.
Yes,
Let him
with his
assist us
permission.
on your behalf.
With his permission, sir. Only one thing, sir.
Your point we have well taken.
Sir, it depends on some district,
Kindly
some
give
states,
them-
sir.
give us the-
We have suppose 44 district. We have 23 district. Now SDM is depends on the district wise. Now whatever we have the strength, we have included all.
Alright,
We are
are you-
cooperating to them
Are you
all.
prepared- are you
Micro,
prepared to provide class 2 group?
yes, we have given, sir. Whatever they are,
Alright.
we have given. But they are telling
All right, please.
what I don't believe.
I think we will be able to find out a practical solution.
Very well.
On Monday when issue notice.
Lords, just I have one apprehension, that's all I have. I don't want Mr. Dwivedi coming on Monday and saying now we have finished 1.2 crore hearings as a figment of his
It's all right.
numbers.
We are entitled to our defense.
That's what you're saying.
That's an ongoing exercise that will
Sir, only my last submission, sir. Sir, what about they have only first place 58 lakhs deleted. They didn't have any scope to appeal even Form 6. Number 2, the second phase, 1 crore 30 lakhs. Only my request would be, whatever the system is maintaining the other state, they are only targeting Bengal. Only for Bengal, they appointed these micro observers.
Not the forum, Millet.
Yes, for to bulldoze the West Bengal people. Sir, my humble submission will be, sir, the logical discrepancy case not to be deleted. And there should be, as it is, it should be cleared by the DO and the ERO, not with the micro observer, not with the roll observers.
Millet, they as well see your lordship's directions on the last occasions.
give us the list of the officers whom you can spare,
Yes.
whom you can spare.
Yes.
Probably, once the officers are made available,
Yes.
then micro observer will not be required.
Not be necessary, absolutely.
Millet will
yes,
Yes, absolutely.
Can do it.
whatever the
And on
rule they
Monday
are
itself, we are taking up the matter on Monday. Meanwhile, they will also get instructions and you also give us that list.
Very well.
Mr. Diwan, please ask your junior to give
Yes.
complete set of paper book.
Of course.
In both matters, we'll.
Both matters. And in Mr. Gopal's matter, very learned in
Sir, or with my humble regards, I convey my great regards
personal pain.
and I will just tell, save democracy.
1 minute, madam.
Joy
Save
Ghosh
democracy.
is a renowned author, Jnanpith Puraskar awardee. There might be some mistake, please, you tell your officers also to be a little bit sensitive.
We'll examine, Millet.
Don't issue notice
Millets.
to persons like.
We have never been divorced from common sense.
Unnecessary embarrassment.
We are addressing them.
Only some
If they
extra
want
time
to
is
make
required to be
sensationalism,
spent.
that's
No,
it.
just one last thing I want to flag. When we argued the merits in Bihar, your lordships noticed this logical inconsistency, etc., were not issues there. The problem is, every time a new state comes up, there will be a new issue which has absolutely no constitutional.
Every day
legal
changing the decision.
State may have
So
its
now
own
after
problems,
this, it will
as
come
they
up.
have been creating.
New issue.
Mr. Gopal,
Yes.
every state will have some new issue.
Exactly.
It is bound to be also.
But
because
it has to have a legal basis. Without a legal basis, they can't start examining something which is not from the
If
draft
the
rule at
state
all.
government fights a constitutional
issue
body,
notice-
what could be the legal
Issue
basis?
notice in both the matters. Issue notice, then assisting counsel wants to accept notice in behalf of the Election Commission of India, wants to accept notice on behalf of the Chief Electoral Officer West Bengal. Then say we have briefly heard Sir Shri Shyam Diwan and Gopal Subrahmanyam, then senior counsel on behalf of the petitioners. And Sir Ms. Dwivedi and Rakesh Dwivedi and Ms. Naidu, and senior counsels representing the Election Commission of India. During the course of hearing, it is pointed out by learned solicitors of India that there is another petition hearing number so and so, and the issues raised therein or the affidavit filed by Election Commission of India will have some bearing on the merits of these cases. Consequently, that order, petition is also ordered to be taken up along with these cases on Monday, due to date of the Monday. The parties shall have respective instructions on the date fixed.
Great.
We'll take up on Monday.
Monday.
Grateful.
Grateful.
Thank you.
Sir, we are very grateful, sir, for
Madam,
no, of course, sir. Of course, sir. Please protect the people's rights.